constitutional values and principles of governance. This is reinforced by specific constitutional obligations, such as the duty imposed on Parliament under Article 118, 1B, to facilitate public participation and involvement in its legislative and other business. Conversely, the Constitution also provides for indirect democracy. In that regard, Article 1.3 states that sovereign power is delegated to specified organs, state organs, including Parliament and the legislative assemblies of county governors. Moreover, Article 94.1 of the Constitution provides that the legislative authority of the Republic is derived from the people and at national level is vested in and exercised by Parliament. This speaks to the representative aspect of democracy, which grants elected representatives the discretion to make legislative decisions on behalf of the people they represent, with the legislative discretion being balanced by the Constitution's commitment to participatory governance. End of quote. While it is unquestionably correct that Articles 110 and 118 of the Constitution apply to all state organs and to all public business, it does not follow that every discrete act of Parliament is intended or is attended by a mandatory public participation obligation. The vote contemplated by Article 149.1 is a discrete, constitutionally prescribed electoral act. It is not the making of a law, it is not the formulation of a policy, it is not the implementation of a public program. It is a binary determination of acceptance or rejection of a single presidential nominee, in which there is no middle ground, no policy choice to be made, no legislative text to be drafted, and no program to be designed. Public participation, the purpose of which is to inform deliberative and policy-oriented public decision-making, would add nothing of constitutional value to a binary vote of this character. Furthermore, even where one to extend the concept of public participation to encompass public observation and accountability, we do find that the proceedings of the National Assembly on the nomination of His Excellency Kindiki were conducted in a fully open and transparent manner. The debate was televised, the proceedings were recorded in Hansard, the press was free to report, and members of Parliament were directly accountable to their constituents for the manner in which they exercised their votes. We are therefore satisfied that this openness and transparency, which is the constitutional core of Article 118.1a's requirement that public conducts its business in an open manner, was amply satisfied. For the foregoing reasons, we hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149.1. Next, I will look at the main issue on constitutionality and legality of the standing orders. The petitioners asked this court to consider and pronounce itself on the National Assembly's Standing Orders number 64.2 and 65, as well as Senate Standing Orders 75, 78, 79, and 80. Beginning with the National Assembly, some of the petitioners assailed the constitutionality of Standing Order number 64.2, contending that the provision imposed an impermissibly truncated 7-day timeline for the disposal of impeachment proceedings. They argued that such compressed timelines undermined meaningful public participation and curtailed the rights to a fair hearing guaranteed under the Constitution. Constitution. They thus prayed for a declaration that Standing Order 64-2 is unconstitutional, null and void to the extent that it prescribes a timeline that is incompatible with constitutional requirements for public participation, fair hearing, and compliance with court orders, and an order of certiorari to quash Standing Order number 64 and 65 of the National Assembly standing orders to the extent that they apply to the Deputy President. The respondents in answer defended the constitutional validity of Standing Order 64-2 and 5, contending that they are necessary for the expeditious conduct of impeachment proceedings. They pointed to the Constitution itself as a source of the condensed timelines, including Article 145(2)(a), which requires the Speaker to notify the Senate within 2 days, Article 145(3), which requires the Senate to convene within 7 days, and Article 145(4), which requires a special committee to report within 10 days, and submitted that it would be illogical to impugn a standing order that prescribes a 7 to 12-day time frame when the Constitution itself operates within a similarly compressed time frame. The respondents further submitted that Article 124(1) expressly empowered each House of Parliament to make standing orders for the orderly conduct of its proceedings, and that Standing Order 64(2) is a legitimate and necessary operationalization of that constitutional framework. They urged the court to exercise restraint in accordance with the separation of powers on the issue. Having carefully considered the rival contentions of all the parties, we now pronounce ourselves as follows. It is right that standing orders are subordinate legislation, deriving their authority not from Parliament itself, but from the Constitution. Article 124(1) of the Constitution expressly empowers each House of Parliament to make standing orders for the orderly conduct of its proceedings, including those of its committees. Article 124(2) further entrenches the role of parliamentary committees within this framework. Being creatures of the Constitution, we agree with the submission that standing orders must at all times conform to the spirit of the Constitution, its values and animating principles. They cannot rise above the instrument that gives them life. Standing Order 64 prescribes the procedure for removal of the Deputy President under Article 145 of the Constitution. Standing Order 65(2) extends this procedure with necessary modifications to the impeachment of a Deputy President under Article 151(b) of the Constitution. Standing Order 64(1) requires that a member seeking to initiate such a motion must submit it in writing to the clerk, clearly stating the grounds of removal supported by at least 1/3 of all members. The motion must particularize the alleged gross violation of the Constitution or other written law, cite the precise provisions alleged to have been violated, and be accompanied by evidence sufficient to substantiate the allegations. The specifically impugned provisions, Standing Order 64(2), by the Speaker within 3 days in accordance with Standing Order 47, and thereafter by the Assembly within 7 days of notice. Should the Assembly fail to act within that period, the motion is deemed withdrawn and may not be revived in the same session save with the leave of the Speaker. The combined effect is that once an impeachment motion is properly filed, it is subject to strict and unforgiving timelines: 3 days for the Speaker's action and 7 days for the Assembly's disposal, failing which the motion lapses in its entirety. It is these rigid timeframes that the petitioners impugned as unconstitutional. Now, the constitutional provisions engaged by the challenge are uncontested. Article 2(4) of the Constitution, which provides in terms that admit of no ambiguity that any law, including subordinate legislation that is inconsistent with the legislation with the Constitution, is void to the extent of the inconsistency, and any act or omission in contravention of the Constitution is invalid. Article 50, which guarantees the right to a fair hearing, and Article 10 and 118, which further enshrine public participation as a constitutional obligation binding on all state organs, including Parliament, in the exercise of their functions. We have examined at length the constitutional requirements and parameters that govern public participation in impeachment proceedings, and we have set out the applicable principles in detail in the preceding sections of this judgment. In determining whether the timelines in the impugned standing orders contravene these constitutional imperatives, it is not lost on us that Parliament is not a resource-constrained institution. It possesses the institutional capacity, the administrative infrastructure, and the constitutional mandate to reach every part of the Republic through its structures at both the county and national levels. If Parliament genuinely considered 7 days to be a sufficient window for public participation, it bore a corresponding constitutional obligation to deploy its resources adequately to ensure that the process was not merely open in form, but accessible in fact, and that it met the participation threshold authoritatively settled in the BAT decision. A compressed timeline, standing alone, is therefore not necessarily a constitutional infirmity. A compressed timeline, accompanied by an under-resourced and inadequately facilitated process, is an altogether different matter. Still, the question that this court is required to answer is whether 7 days, encompassing the logistical demands of public notification, the organization of participatory forums across a diverse and geographically expansive republic, the receipt and meaningful consideration of public input, and the Assembly's own deliberation on a matter of this constitutional gravity is structurally adequate to meet that threshold. We draw from the Supreme Court of Canada's holding in Hyde Nation versus British Columbia, Minister of Forests, a 2004 decision, that the adequacy of any participatory process must be measured against the gravity, as we have said, of the decision that is being made, and that the more consequential decision, the more robust the participation exercise must correspondently be. At the same time, we are mindful of the importance of according appropriate deference to Parliament in the regulation of its internal proceedings as required under Article 124(1) of the Constitution. In the Supreme Court decision in the Speaker of National Assembly versus Attorney General, the Supreme Court stated that the court would be averse to questioning parliamentary procedures formulated to regulate internal workings, and the court would not do so as long as the same do not breach the Constitution. Having regard to all the foregoing, we do not consider it warranted to declare Standing Order 64(2) unconstitutional. A declaration of unconstitutionality is a remedy of last resort and a judicial act of the gravest constitutional consequence, not to be visited against upon rather a legislative provision where the provision is capable of a constitutional interpretation or application. We are further guided by the principle of constitutional avoidance that where a provision of subordinate legislation can be read and where it can be applied in conformity with the Constitution, the court ought not to strike it down when a less drastic remedy is available. This principle was affirmed by this court in IEBC versus Minor KI and 5 others, where it was held that interpretive generosity must extend where reason permits to the provisions whose constitutionality is challenged. We are not persuaded that the mere existence of a 7-day timeline taken in isolation and on its face renders Standing Order 64 void. A provision is not unconstitutional simply because it is capable of being applied unconstitutionally. The vice lies not in the number of days prescribed, but in what Parliament does or fails to do within those days. The timeline, considered as an abstract legislative proposition, is therefore not in itself the source of any constitutional infirmity. The infirmity, where it arises, lies in the manner of implementation, and in whatever Parliament operating within that compressed window deploys. Whether Parliament, operating within that compressed window, deploys adequate resources, establishes genuinely accessible structures, and puts in place meaningful mechanisms sufficient to discharge its constitutional obligations of public participation under Articles 10, 50, and 118 in substance and not merely in form. The distinction we draw is between a provision that is unconstitutional on its face and void in all its applications, regardless of how it is applied, and one that is conditionally constitutional, as in valid in law, but only where its application is accompanied by the institutional effort and constitutional seriousness that the gravity of impeachment proceedings demands. Standing Order 64-2 falls, in our judgment, in the latter category. In declining to strike down Standing Order 64-2, we instead note that the timeline prescribed in that standing order is not constitutionally mandated. Unlike certain procedural requirements that derive their specific content from express constitutional text, the 7-day window is a creature of parliamentary regulation alone. Parliament was free to prescribe a longer period and still remains free to do so. The experience of the first impeachment of a deputy president to come before the National Assembly under the Constitution of Kenya 2010 might have been a sobering constitutional experience. It may have exposed in real time the structural tensions that compressed timelines have the potential to create when applied to proceedings of national consequence. We commend to Parliament for its serious consideration in the exercise of its sovereign authority to regulate its own proceedings, the question of whether the timelines prescribed in Standing Order 64-2 remain adequate in light of this experience, and whether a timeline that builds in more time for public participation and for the Assembly to deliberate with the gravity that removal from constitutional office demands would not be more befitting of the constitutional moment that the impeachment invariably represents. As it stands, however, we find nothing unconstitutional about the standing order. With respect to the Senate standing orders, the petitioners assail the constitutionality of Standing Order 75, 78, 79, and 80 to the extent that they apply to the Deputy President, advancing their challenge on 3 grounds. First, that Standing Order 79 was a mechanical importation of the presidential impeachment framework to the Deputy President's distinct constitutional position without any effort to modify the required to identify the required modifications as required by Article 150 to 152. Second, that the appointment of a special committee was mandatory under Article 145(3)b, and that Standing Order 79 did not mirror this requirement. Third, that the 14-day timeline under Standing Order 75 was structurally incompatible with Articles 47, 50, and 145.5 and was grossly inadequate for proceedings involving 11 complex constitutional allegations. The respondents maintain that Article 145.3b uses the word may, which confers a discretion and not a mandatory obligation, that the fact that Standing Order 80 expressly provided for a plenary alternative, while Standing Order 79 did not, was constitutionally significant, as the discretion was conferred by the Constitution itself. They further submitted that Article 152 did not require a formal or recorded exercise of identifying modifications, and that the modifications were implicit in the different constitutional status of the Deputy President. They relied on Speaker of the Senate and another versus Attorney General and another for the proposition that courts should not read into the Constitution obligations that its framers deliberately chose not to include. We have considered the submissions put forward by the parties, and for the avoidance of doubt, standing orders, we provide verbatim what the Standing Order 75, 78, 79, and 80 all provide. Allow me not to go through that. The principle that standing orders must conform to the Constitution applies with equal force to the Senate as it does to the National Assembly for the reasons we have already set out in the preceding section of this judgment. Our jurisdiction to examine that conformity is equally settled and will rely on the case of Orange Democratic Party versus Speaker of National Assembly and Ombogi and 9 others versus County Assembly of Nyamira. We note that Standing Order 78 largely mirrors the impeachment procedure provided for under Article 145. As such, the question of whether the special committee contemplated under standing orders is mandatory or discretionary, and the constitutionality of those standing orders is in the context of Article 145.3b is addressed separately in the next ground. On the specific challenge to the absence of a formal